Judgment in the appeals, the Queen against Mackle and the Queen against McLaughlin.
Lord Kerr will give the reasons for the court's decision.
Three brothers, Patrick, Jude and Benedict Mackle, all pleaded guilty to having been knowingly concerned in the fraudulent evasion of duty on cigarettes, contrary to Section 170, subsection 2A of the Customs and Excise Management Act of 1979. And in a separate trial, Henry McLaughlin pleaded guilty to a similar offence. An application for a confiscation order was made against all four defendants. A confiscation order is made against someone who has benefited financially from criminal conduct. In these cases, it was claimed that the defendants had so benefited because they had evaded duty and value-added tax, which was payable on the cigarettes. They were wrongly advised that they were liable for the duty and the VAT, and on that basis they consented to the confiscation orders. Later, they received fresh legal advice to the effect that they were not, after all, liable to pay the duty. So they went to the Court of Appeal in Northern Ireland to ask that the confiscation orders be set aside. The Court of Appeal refused to do that. It decided that since the defendants had consented to the confiscation orders, they were bound by them. In any event, said the court, the defendants could have been held to have benefited in some other way from the smuggling of the cigarettes. All four defendants appealed to this court, and we have unanimously allowed their appeals. In the first place, the Court of Appeal was not referred to decisions of the House of Lords and of the Court of Appeal in England and Wales, which showed that consenting to a confiscation order made under a mistake of law does not bind the person who had consented. And following those decisions, this court reversed the finding of the Court of Appeal in Northern Ireland on the first ground. On the second ground, the Court of Appeal thought that the confiscation orders could have been made on a different basis from that on which the sentencing judges had made the orders, because the court felt the defendants might have benefited from their criminal conduct in some other way. But the law under which the confiscation orders were made requires that it be shown that they had in fact benefited financially, and that had not been established in the hearings before the sentencing judges. We have therefore quashed the confiscation orders, but we have sent the cases back to the original trial courts so that it can be determined whether the defendants have benefited financially from their criminal conduct other than by evading duty on the cigarettes.